My lady, if I could proceed to make some submissions now on the BINCO notes and the
Yes.
book by Mr. Davies. May I start with the BINCO notes, please? These are in the core bundle rather than the authority bundle. They're at tab 2. And a particular section dealing with clause 29 starts at the bottom of page 56. I'm going to invite you to read it in a second because it's very short.
Sorry, I'm.
So, core bundle, my application bundle, page 56.
Oh, right, thank you. Sorry, I thought we said tab 2.
It is in my tab 2. Does the court have tabs in there? Core bundle or only pages?
It's at the back of the skeleton.
Yes.
Oh, cool. Sorry, beg your pardon. I'd take your skeleton out, which explains.
No, yes, cool. So, yeah, 56, so with my learning friend skeleton.
Yes.
I'm going to invite the court to read it in a moment. Just before I do, just like to express in a nutshell what my submission is on.
Certainly.
That is that the treatment of clause 29 in the BINCO notes, whilst it's very brief and it doesn't offer any comprehensive guidance about the clause, insofar as it does shed light on it, it supports the Charterer's case and is contrary to the tribunal's conclusion on clause 29.
Can you explain to those of us not so familiar with this what BINCO is and what these notes are?
By all means. So, sorry, the BINCO stands for Baltic and International Maritime. Thank you. So, Baltic and International Maritime Council. It is an association which includes both ship owning and chartering interests. And what they do is attempt to facilitate the business of shipping by drafting either complete contracts, both complete contracts and also clauses addressing particular issues which parties can incorporate into other contracts. Those, of course, are drafted by committee, whether that's a good idea or not. They are drafted by committee and published by BINCO from time to time. This bareboat charter is on a BINCO produced form, BareCon 2001.
And it replaces a previous version, presumably.
I am not certain that there was a BareCon prior to 2001. There may be, I'm simply not aware of it. Apologies. It has been replaced by a 2017.
I thought I saw some reference somewhere to it strengthening the position of owners, which suggests that there was a previous position to be strengthened.
I follow that. It's simply that I'm not in a position to submit or tell you that.
Yes, I see. Thank you very much.
It probably strengthens the position in the sense that as what it would otherwise be, doesn't it? Because on the face of it, when there's a termination, the charterer can just walk off the boat. And this is strengthening in the sense that it is making a contractual provision for them to be gratuitous bailies.
My lord, I submit that is correct. It's simply that I do not know whether there was a previous version or if there was.
I'm just looking at page 41, which is the first page, and there's a reference there to something called BareCon 89, which suggests that there was a 1989 version.
In which case, Lord Justice Nugee has found the answer for us.
Yes, but we don't have it. We don't know in what respect 29 amends the previous position.
We do not. Again, if the court wishes us to find those materials, that I'm sure that can be done. So I don't want to make it seem as though these BINCO commentary is an enormous thing. As you'll see from my submissions, I have some points to make about it, but they need to be kept in context. The admissibility of this note hasn't been disputed between the parties. Just for the note of the court, I don't spend massive time on its admissibility because my learned friend put it in. I'm not objecting to it. The admissibility of BINCO documents and commentaries has been commented in a couple of cases. My learned friend has put those cases in, referred to them in his skeleton. In particular, a key paragraph is paragraph 21 of the case, the Demetrius L, and the court will find that at page 30 of the authorities.
Do you want us to turn that up?
I would prefer, subject to the court's views, I would prefer to spend time on other matters. because
Yes,
it's
no,
simply
It
not
doesn't
fair.
seem a very surprising proposition because the investor compensation scheme of West Bromwich tells us that we can admit anything which is reasonably available to the parties. Presumably these notes are available to anybody.
Indeed, and there is helpful discussion of that in the Demetrius L case.
Let's
So,
concentrate on the content then, shall we?
turning to the content. So that was, can I ask the court then just to spend a minute to read from the bottom of page 56 on to page 57. There are two paragraphs.
Certainly.
29. So the Demetrius L, again, in a nutshell, observes that when one's looking at documents such as this as background, it's factual matrix in effect. One is not saying that you try and identify the subjective intentions of the BIMCO drafting committee, nor do you assume that the subjective intentions of the parties are the same as you found the subjective intentions of the draftsman. What is said in the Demetrius L is that it is admissible if it helps to show what was the commercial context and purpose of the clause that is being drafted. What's the aim of that clause? What was the problem that it's addressing?
What's called the mischief in statutory interpretation.
I would accept that analogy. Yeah. Now, these BIMCO notes that we have here do not point to any mischief for which preferring the owner's construction over the charterer's construction is a solution or the solution. So that's really my main point here. And in reality, I submit once the usefulness of the BIMCO notes, it is useful up to that point, and that effectively is. One cannot say that these notes have pointed to there being a mischief that vessels get made available in a port where it's objectively convenient to put a master and crew on board, or to use the tribunal's finding, where it is reasonably practicable for the owners to repossess at that port. But then this is considered to be a problem and a mischief and needs to be addressed by wording which gives the owners other options in that scenario. Quite on the contrary, there is a different mischief identified. You can see from the text, the bottom of 57 going on, sorry, bottom of 56 going on to 57. It's thought to be a problem that it at least can happen that vessels get abandoned or not properly cared for, or charterers leave them somewhere where it's difficult for owners to repossess, and the solution that is then identified is the gratuitous bailment obligation. This strengthens the owner's position by ensuring that the vessel is cared for and the charterers are under a duty to care for it until the owners can repossess her. And you'll see about 4 lines down at the top of 57, charterers must care for the vessel without compensation. I'll come back in a moment to the words without compensation. Until the owners can physically repossess her. So this shows, I say, that the thinking here is that the timing of repossession occurs when the owners can physically repossess her, being governed by that obligation on the owners to repossess the vessel as soon as reasonably practicable, allowing no room, no scope for the timing of repossession to be at some later point in time of the owner's choosing, driven by the owners having elected that the vessel should be sent to some other place of their own choosing. That all of that underlines the importance of the third sentence and the obligation to repossess as soon as reasonably practical. In all of this commentary by BIMCO, there is not a whisper of a suggestion of the owners having a right to make an election, nor any suggestion that if the vessel is at a convenient port when the charter is terminated, then the owners are required to sail the vessel to some other place that they can elect based on greater convenience. I said I'd come back to the words without compensation, where they say at the top, the charterer's rights have ceased, but their obligations don't cease, is what BIMCO say, and then the charterer must care for the vessel without compensation. Now, there is no mention here in the BIMCO notes of the correlative right that the charterers have as a gratuitous bailee caring for the goods to be reimbursed for the costs of caring for the goods. That correlative right appears to have been overlooked, at least as far as one can tell from this brief discussion in the BIMCO notes. Now, that may in fact be the case because the correlative right was given great, or certainly much greater prominence to shipping lawyers than it previously had by the important case of the COS, which is in the authorities on tab 5, and it's a 2012 decision. Again, it's not controversial between the parties, so I don't wish to make a lot of submissions on it, and nor did the cause, so to speak, change the law, because it based itself on the 1980s case of the Winson. It simply underlined, and by the way, the Winson and the cause were both cases involving bailment of cargo on ships rather than bailment of ships to charterers. So they were not directly in point for a bareboat charter. But they did turn on a general principle that where there is a non-contractual bailment, then the bailee has the duty to care for the goods, but is entitled to be reimbursed for the costs. Does the court have any questions on that particular?
So you accept, I think you accepted before the tribunal, that the owners are obliged to recompense the charterers for actual costs incurred in taking it wherever you have to take it, whether that's to the next port or to some convenient place, whatever that means. Does that include, well, that obviously includes bunkers, does it include wages, does it include insurance, does it include other things?
All good questions. So to answer them in turn, it was our positive case in the, sorry, it was the charterer's positive case in the arbitration that we were entitled to be reimbursed the costs of caring for the vessel, either in bailment under the correlative right, or as a matter of unjust enrichment, or pursuant to clause 29, where we alleged there was a breach of clause 29, in which case it was recoverable in damages. So by all means, yes, we relied on the correlative right. The costs of caring for the vessel, I submit, would certainly include the crew, would very likely include all reasonable maintenance, because that's what's required to keep the vessel running safely, in good order. Insurance, technically, probably not, or at least not necessarily, but our claim did involve insurance, and I do submit that it was reasonable to include it. It certainly was not being insured by the owners at the same time, so the charterers continued insuring the vessel until the owners had repossessed her at Gibraltar.
Yes, I see.
And those costs were allowed in principle by the tribunal, subject to its decision that because we had been wrong about clause 29, the time spent at Mexico and the time spent under arrest at Gibraltar were not recoverable.
So you got the costs of actual voyage from Mexico to Gibraltar,
That's correct.
and that included crew, bunkers.
It did.
Yes.
Crew, bunkers, and various miscellaneous expenses that were part and parcel of operating the ship. And there's a breakdown set out in the award, I think it's paragraph 140.
But the point is that because the tribunal found that you should have sailed Croatia, you are not entitled to compensation for the period during which you were in Mexico. Is that right?
Indeed, in effect, my lord, I submit it was that we, the charterers, had breached our obligations to depart from Croatia on the 21st of May. We therefore couldn't claim costs incurred while we were waiting in Mexico because we were incurring them effectively as a result of our breach of clause 29 as the tribunal had construed it. Which, in principle, I do not criticise.
If they're right on construction, then what the tribunal did follows, doesn't it?
Precisely, my lord. Yeah.
Yeah, because clearly you weren't going to be entitled for the costs of the standoff, if I can call it that.
Well, at least I am not interested in attempting to debate any idea that I could be.
Yep.
Whether if we were starting from the very beginning, I might try and run some point about we're still a Bailey, etc. I don't know. But I'm not interested in running such points now.
Fine.
And we have not criticised the tribunal's reasoning in that respect. We've criticised only their premise.
Yep.
Clause 29. So
I can't forbear from saying it would have been a Mexican standard.
We fed you that line.
So, if I can just come then to what BIMCO made of this, it may be that they had overlooked the cause and the correlative right. Now, the owners.
The cause hadn't been decided by the time.
That's right. Maybe they had overlooked the Winston and the correlative right.
Yes.
And the owners do not certainly derive any benefit if that is what had happened when this contract was drafted. Because if the thinking and the mischief as identified and so on was based on a premise that the charterers would have to take care of the vessel's gratuitous bailee, but be entitled to no reimbursement of the costs of doing so, then that just serves to underline how unreasonable the owner's construction of the first sentence of clause 29 is. Because then the owners, as this case illustrates, would be able to put the charterers to the enormous expense. Here it happens to be something like $650,000, could be anything, and have no recourse for that at all. And that just serves to underline that that's really a commercially impossible construction. Finally, just on the BIMCO notes, I think I should say for the record that in the arbitration there was no pleaded case from the owners relying on it, as factual matrix or otherwise. It was only introduced in the trial skeleton of the owners, and on the Section 69 appeal, the owners did not seek to put BIMCO notes before the court at first instance on this Section 69 appeal. So it was not in front of His Honour Judge Pelling Casey when he was looking at these matters, and he refers in his judgment to the fact that it was not before him, but he could see it mentioned in the tribunal's award, and he considered that it provided very limited help. Now, if I could please come to the other authority on clause 29, using that expression loosely, in the authorities bundle tab 8. We have this work by Mr. Davies, Mark Davies, on bareboat charters. It's a respected practitioner's work of law, and it's part of a respected series. It's now published by Informa. I think it was previously known as the Lloyd's Legal Publishing or something like that. But they have a series on time charters, voyage charters, and so on, which are leading practitioners' texts in those topics. And this is the one on bareboat charters. The part dealing with clause 29 is at pages 112 to 114. And I will ask the court to take a look at paragraph 29.1. Look at all of them. 29.1, if I can ask the court to look at that first. It is effectively just a very quick introduction to and glossing of clause 29. Here in clause 29, paragraph 29.1, the only specific point to underline is that it does mention the clause addressing the owners being in a vulnerable situation. It's the penultimate line on page 112. But the example given there is being unable to repossess the vessel when it is on the high seas. That is what is highlighted there as an example of a vulnerable situation. Again, no suggestion that it is problematic to have a vessel made available for repossession in an objectively convenient port.
I say for my part, I do start to feel that we need to see fair conduct in this. I tried to look it up, but people want you to pay for it.
I'm sure between ourselves, my learned friend could make it available. We might, if I could.
You want him to pay for it?
But we might, if we could perhaps confirm at the end of the day, we might perhaps request the court's permission to put in very brief submissions dealing with it, if that were allowed. But perhaps this isn't the best.
You don't by any chance have it about your person?
Unfortunately, I don't. But my understanding is that it's silent on repossession, which is
Yes.
why this clause.
Well, of course, because we're told it's a new clause to address the difficulty of what happens when people abandon.
Tantalisingly, one of the providers showed it, and then it sort of dissolved unless I paid. And I could see from that very brief that it doesn't say anything about repossession. So this all seems to be entirely new regime. But well, perhaps we should say no more until we actually see the documents.
But it's a helpful request from the court, so I'll certainly take it, I imagine my learned friend. So, looking at then within this regime, if the court is on page 113 of the authorities bundle, please, I will ask you to take a look at 29.2, which consists of 3 sub-paragraphs. I could again ask the court to read.
Certainly.
Thank you. And insofar as what it refers in the first line of 29.2 to lines 851 to 857, you can see from the previous page that is pointing precisely to the first sentence of the clause that we're all concerned. So here we are under the heading repossession, and crucially at the end of the first subparagraph in clause 29.2, Mr. Davies says that the lines 851 to 857, this provision does little more than express the owner's common law right to repossess their own property. We're not in the world of factual matrix here as per BIMCO, we are in the world of respected academic commentary. And this respected commentator is saying that the first sentence of clause 29 does little more than express the owner's right to repossess their own property. So it is crystal clear from 29.2 that Mr. Davies does not consider clause 29 gives the owners an entitlement to elect to have the vessel taken to some different place based on the owner's sense of what is convenient or most convenient to them.
A common law, if a bailment is terminated, if a lease is terminated of a chattel, it's for the owner to go and get it rather than for the lessee to deliver it. I think that's common ground, isn't it?
It is certainly common ground that, yes, that if the obligations exist only in bailment, then there is an obligation on the bailee to allow the owner to take the chattel back, but not an obligation to take the chattel back to the owner. And if Mr. Davies had thought that clause 29 had the effect that the owners are contending for, that would be a momentously important point for the shipping industry, and it would certainly be a point that would merit mentioning in his discussion of clause 29. And there's absolutely no shadow of a suggestion of it, and I submit that supports the charterer's case. Within 29.2, the third little subparagraph, starting with the words lines 860 to 865, is discuss the obligation to repossess the vessel as soon as reasonably practicable. There's no suggestion that that is dependent on the charterers first having to do something which owners are entitled to demand.
There's a suggestion which perhaps comes more up from the BIMCO notes than this, that in introducing the gratuitous bailment into the scheme, the obligation to take repossession as soon as reasonably practicable is almost a quid pro quo. And if you're going to make the charterer a gratuitous bailee, they can't just walk off quayside. Equally, there must be an obligation on the owner to take possession as soon as reasonably practicable.
Yes, I mean, that has always been our case in this dispute before the tribunal and before the judge, that it is a very balanced and rational allocation of responsibilities, because it ensures that possession does happen as soon as reasonably practicable. It thereby avoids prejudice to either party, and I can deal with that more in my submissions about commercial reasons, but absolutely, it makes sense to see them as two sides of the same concept. You avoid all possible, to the extent possible, you avoid unnecessary prejudice or inconvenience to either party. I'm hesitant to make anything more complicated, but since my Lord Justice Nugee this morning mentioned the potential sort of drafting infelicities in the clause, there is an observation I wish to make about the middle paragraph in 29.2. I'm sorry, this is not directly on point, it's a side point. But it's said here that referring to the owners have a right to repossess them without hindrance or interference by the charterers, courts or local authorities. And it says they're inapt Mr. Davis says they're inapt as they refer to the courts, but is submitted the intention is clear. So again, Mr. Davis thinks there's a little bit of imperfection in the drafting, but the intention is clear. And I might even submit that the likely intention or a plausible reading of those words is that it's meant to make it wrongful for the charterers to try and use courts or local authorities to get in the way of the owners taking back their own property. That may have been and may be a plausible reading of Clause 29.
Well, clearly the parties can't, by contract, stop the court from doing what the court does, because the court's not bound by the contract. But you can, as you suggest, put a contractual obligation on parties not to resort to litigation improperly.
Yes. So at least, I mean, my case does not depend on this, but the suggestion I would make is that this may well be what is intended by the words, without hindrance from courts and local authorities. As a matter of obligation on the charterers, it's don't go off to court and try and get an order that blocks me from taking back my own property. Now, if that's right, it's just another example really, of a very compressed verbal formulation being used in an attempt to achieve something where it could have been spelled out more clearly if they'd taken more space to spell that out. So it's just another example of compressed drafting. Okay, now I'd perhaps better come back to the crucial points. Still in Mr. Davis's book, paragraph 29.3, please. Again, if I could please ask the tribunal, this is the one that has a big black bar to the side and goes over onto the next page. Sorry, if I could ask the court to review that, please.
Sorry, I missed the reference.
We're in Authorities Bundle, page 113, towards the bottom, paragraph 29.3.
Oh, I see. Yeah, 293.
So, again, nothing actually supportive of the owner's case here. Two main points to make to the court. Firstly, it does refer here to situations where the vessel is in an inconvenient port, the high seas or at a distant port. Inconvenient location is specifically mentioned here. And yet, even in that context, it does not say that how the clause deals with it is by giving the owners the right to select the place of repossession. It says it deals with it by the obligation to care for the vessel as gratuitous may be. Second point, in the discussion of the bailment gratuitous bailey obligation, again, it doesn't mention the correlative right to reimbursement. Again, it suggests that the assumption may have been there was no entitlement to be reimbursed for the costs of caring for the vessel. And again, that would make it extremely unlikely that the objective intention was for the owners to be able to do what owners did in this case. Now I'd like to move to my third main topic, which is this arguments about commercial reasonableness of the rival constructions. And to recap, our position is that charterer's construction avoids either party being substantially prejudiced. So it's a fair, even-handed, efficient solution. And by contrast, we criticise the owner's construction because, as the judge pointed out, it would result in the charterers being subject to a very significant prejudice in a plausible and foreseeable scenario where the charter was terminated based on an an insolvency event affecting the owner or the owner's guarantor, such that on the owner's construction there would be this obligation to incur significant upfront costs when owners may not be good for the money.
I think the tribunal accepted that, didn't they? It said that the wording of the clause required it.
Indeed, they said they were driven to it by their view as to what the express or ordinary meaning of the clause was. We of course disagree with the tribunal fiercely as to what you can in fact find stated in the express wording of the clause. The owners have made about 3 major arguments against this point on prejudice and reasonableness, and I'm concerned to address each of them as efficiently as I can. Now, the first of these is to say, to assert that, well, don't worry about prejudice to the charterers on the owner's construction, because clause 29 applies to a range of different situations, and therefore it will inevitably cause prejudice to someone. Since it covers a wide range of situations, it's inevitably going to prejudice somebody. This argument is made in the owner's skeleton paragraph 56 and paragraph 71. But we say that is wrong. The charterer's construction doesn't prejudice anyone, because being obliged to repossess the vessel as soon as reasonably practicable is a fair allocation of responsibility. I say again, as I confirmed in response to Lord Justice Phillips' question, that yes, we have been submitting since the outset that there is a bargain in clause 29, and that is obligation to care for the vessel matched by obligation to repossess as soon as practicable. Now, central to the owner's argument is this idea that if the charter is terminated when the vessel is located at or near an objectively convenient port, then the owners are somehow still prejudiced by being obliged to repossess there as soon as practical. And our argument has been that is not prejudice, and in particular to underline it's not prejudice inter alia, well, firstly and obviously because it is a fair allocation of responsibility, but also it is very similar to what the owners were expecting to have to do at the end of the charter party. Now, I entirely accept that the redelivery situation and the repossession situation are not identical, and there is no automatic read across. And it would be facile to suggest that there was. And so certain questions which my Lord Justice Phillips put to my learned friend saying that the redelivery and repossession situations are different, my answer to that would be also to accept that they are different. But it is nonetheless relevant to consider them as an answer to the owner's arguments. You were taken, the court was taken already to box 16 of the charter party, 50. I think it was page 93.
188.
Yeah, so 188 is box 16, inserted words, basically a worldwide range, and then clause 15 is 193, sorry, that's why I'm getting 193. So the clause 15 is part of the bare conform itself, although it has been subject to certain very specific amendments here. And clause 15 does envisage that the charterers have the ability to choose where the vessel gets redelivered. So even though box 16 has the charterers, has the parties inserted words in it, those are very normal, basically saying, well, redeliver within international navigation limits at a safe port. That's a very normal option to have, and in effect, clause 15 envisages there will be something like that, because it's an obligation to redeliver at a safe and ice-free port, as indicated. It doesn't say the port indicated in box 16. It says a safe and ice-free port as indicated in box 16. And then it has this regime of notices for saying where and when. So it does contemplate that the charterers have the effectively the ability to redeliver the vessel where their trading of the ship has taken. So the owners were expecting at the expiry of the charter that the charterers would say, we're now somewhere we've been trading the vessel, we're finished, we elect to, or we will redeliver the vessel at place X on about date Y.
But you could have a box 16 which gave the option to the owners.
You could, in theory. It is simply that, well,
it's a bit impractical because it would require the charterers to trade the vessel in such a way that they could end up where they only wanted.
and yes, it isn't. It's simply. I mean, I can't say it's impossible, but it's just not the normal way of doing things, and it's one would not agree to that if one were negotiating a charter bond, unless the owners had enormous bargaining power.
Because the charterers doesn't want to commit itself to where it's going to be in 5 years' time.
And they would have to, in all likelihood, they would have to pay the costs of some sort of repositioning voyage with no ability to profit from it. So it would just be a very disadvantageous term for a charterer to agree. So what the important point here is that the form in itself envisages that there isn't actually, even though it's conceivable, the form envisages that there are multiple possible places it could be, and the charterers are going to need to give notice about which one it is.
Yes.
And that's important because it shows objectively that what is envisaged by the contract terms themselves is that the charterers would choose the place and time of redelivery, albeit that it is smoother because there are these notices given in advance, and that may not be the case with termination. But the owners cannot plausibly say it's a great prejudice against which clause 29 sought to protect them, that they might have to be expected to repossess the vessel at some port somewhere in the world, because that is what they were expecting to do all along. So they cannot describe that situation as a prejudice. It is something which is foreseen by the charter as basically what is going to happen. The next owner's argument is prejudice to the charterers, the type that we are saying is a relevant consideration, isn't much to worry about because it was assumed that it was much more likely to be the owners terminating the charter than the charterers terminating the charter. Now, the owners have been very keen on this argument from the beginning until now that there's some sort of statistical probability here in favour of a termination by the owners. The tribunal themselves did not find any attraction in this argument. They did not cite this as a consideration in favour of their construction, didn't base any of their reasoning on it, and I submit it is lacking in any logical or evidential basis. This is the owner's skeleton paragraphs 58 to 60 on pages 32 to 33 of the core bond. And paragraph 72 as well, which is page 71 to 72. Paragraph 72 on page 38 asks a rhetorical question. The question it is suggested by the owners must be which of the four events of termination in clause 28 the draftspeople have been would have envisaged would inform the meaning of clause 29. I submit the right answer is all of them. And it's not plausible to say that the parties or BINCO thought that the meaning of clause 29 would be informed by saying clause 29 is much more likely to apply to clause 28A than to a 28B situation or a 28C situation. That would be basically privileging some termination events over others. You can see from the express terms in clause 28, including clause 28D, these show that the parties did contemplate the charter might be terminated in circumstances where the owners or their guarantor were subject to insolvency type events. And it's not plausible, really, that BIMCO, when they're drafting clause 29, would have been weighing up in their minds what are the relative chances of a charterer walking away from a charter party versus an owner getting into financial difficulties. There's just no reason to think that that BIMCO were thinking about such matters when thinking about what clause 29 would achieve. And certainly there's no basis for saying, even if they had thought about them, that BIMCO's view would have been that the risk of the owners having financial difficulties or going insolvent is so small that it justifies disregarding such matters when considering how clause 29 ought to work. So just not plausible to construe 29 as though it was really drafted for situations where it's the charterers who are the bad guys. Enough on that one. Finally, the owners say that the consequences of the owner's preferred construction of clause 29 are not that much worse than the consequences of charterers' own construction. Indeed, at times they go as far as to suggest they're not really even worse at all. This argument is in my learned friend Skeleton, paragraph 69.
Minimum significantly overstated and in fact probably wrong.
Yes. And then paragraph 70 goes on to elaborate on that. And there are basically four components to it, if I can just deal with them. The first of them is, if you're in paragraph 70 of my learned friend Skeleton, point A, starting in the second line, point A is, well, the charterers have still got to settle the wages of the master, officers and crew. But that is expected anyway. It's not even a function of our construction of clause 29. These are the charterers, masters, officers and crew. Even without clause 29, we would still need to pay them off. So it is just something that is expected to happen and isn't really a function of clause 29 at all. Not a legitimate reason. Then there is B, penultimate line of this page. Charterers would need to incur the costs relating to crewing the vessel, keeping them insured, ensuring there are sufficient bunkers on board. Now, subject to the insurance point, which may not be technically right, it is right to say that on our construction, charterers do need to incur costs of crewing and caring for the vessel, but only until the owners repossess her as soon as reasonably practical. That's where this whole point about it being a fair, balanced allocation of responsibilities comes in. Because our submission is that the clause draws that reasonable balance, it creates completely different consequences from those which the owner's construction has. And that is illustrated by this case. For example, a large part of the charterer's claim is the cost of the bunkers for the voyage from west coast of North America to Croatia, or Gibraltar, as it happened. Then in going over the page onto page 37 of the core bundle, still in my learned friend's paragraph 70, subparagraph 1, which says there is no guarantee that an owner can get a crew on board quickly, especially a financial institution. And then I'll deal with the fourth point at the same time, which is to say, if the owners are insolvent, it may take the owners longer to repossess the vessel. Now, I have some more detailed submissions to make on both of those, but let me start with the most crucial point, which is the whole argument there is a fallacy. The importing into what they're saying about the charterer's construction. It is bringing in a false premise from the owner's own construction, which is not part of the charterer's construction. I'm sorry, what I've just said is probably like verbal spaghetti. Let me just unpack that. Just try and identify the false premise. The false premise that they're bringing in is that when you are looking at the obligation in the third sentence to repossess the vessel as soon as practicable, the false premise is that that is a subjective standard such that wherever an owner is subject to some idiosyncratic factor which would delay that particular owner in being able to repossess a vessel, that then operates to extend the time that is allowed under the standard of as soon as reasonably practicable. And we say that is just wrong. As soon as reasonably practicable is an objective standard that looks to the ordinary course of business, not something which looks to the peculiar characteristics of the particular owner, such as, are they insolvent? Are they unfamiliar with the shipping industry and clueless as to what to do and how to go about repossessing a vessel, and so on. So it is only by the fallacy of, we say, misreading the third sentence, misreading what as soon as reasonably practicable means, that those arguments can even come into the equation on the owner's argument. And the answer that I've just given, that as soon as reasonably practicable is an objective standard looking to the ordinary course of business, that answers them completely.
So does that mean reasonably practical means what would be reasonably practical for a typical owner?
For a reasonably efficient and diligent shipper, just as if a clause said the cargo must be discharged from the vessel as soon as reasonably practical, that would be an objective standard for the circumstances in question. Because the objective standard may depend on things like the setup at the port, but it's not subjective in the sense of bringing in matters such as lack of capability or lack of finance on the part of a particular.
But it would cater for, say, there being a worldwide shortage of competent crew or something.
Well,
I mean, you don't need to answer.
Yes, I mean, so, but there are also further answers, and I am concerned to address this suggestion, which also relates to the suggestion that there are different types of bareboat charter, and that this court should be, as it were, construing clause 29 with an eye to protect the interests of owners who are not familiar with the shipping industry. That is, as I understand my friend's case, where he is driving at, with the argument that there are bareboat charters involving people who are not ship owners but are only finance parties. So yes, for example, just to make clear what I'm attempting to answer, if you see paragraph 48 on page 30 of the bundle, 48(4) is what I'm pointing to. Suggested in the fourth line of the main body of paragraph 48, clause 29 has to be construed in a way that allows it to apply sensibly whether, for whatever the nature of the ship owner is, whether they're involved in ship operations, a financial institution, or a company involved primarily in the business of ship owning.
Building.
Sorry, ship building.
Well, if you are a ship owner and you have chartered the ship on terms that you will, on termination, arrange repossession as soon as reasonably practical, then you know that you have to have the facility to do that. And it seems to me it's not open to you when it happens to say, we
Very good at
never,
this.
we never thought about this. We can't do this for several weeks. It's part of your business that you're an owner who's chartered a vessel, and arranging to put an authorised representative on board a vessel at a major port, I would have thought is not something which is beyond the reasonable ability of anyone in business.
Well, indeed, and it may therefore be that I can take this extremely quickly. So I accept entirely what my Lord the Justice Phillips said. As regards finance parties, it is the case that sometimes bareboat charters are used as part of ship financing arrangements. In general, though, and I apologise for this as a flavour of giving evidence, where that is the case, where one has a ship financier, such as one of the major Nordic banks that do a great deal of ship financing, for example, these ship financiers are highly capable in terms of what they can do to repossess assets. They don't do it themselves, they don't have crew, they will contract an agency, and if they have advanced money for somebody else to buy and operate a vessel which will be worth millions of dollars, and then there's a termination and they want to repossess their assets, they will do that extremely quickly and they will have no difficulty doing so. And so the whole idea that one looks at clause 29 with an eye to making life easy for finance party owners who may be inexperienced with or unfamiliar with ship owning and therefore may have great difficulties and would find it much easier if somebody brought a vessel to the equivalent of Troguea for them, is just not a plausible argument. Ship financiers are absolutely readily able to do what clause 29 requires.
Is that you giving evidence?
Yes, in effect, my lord, yes. But not more than my learned friend has. And then, finally, the argument I submit doesn't even really work in its own terms, because where one has a party that is unfamiliar with the shipping industry, and therefore somebody who would really be struggle to organise a repossession, that person is most unlikely to have a place in the world where they can say, it would be very convenient to have that ship brought to me there. In this case, is an extraordinarily odd situation of a party which happens to be affiliated to a shipbuilding yard, but it's just not normally the case that ship owners have yard space or dedicated berths, or would be in a position to say there is somewhere where it's really convenient for me to have that vessel taken.
Also, but again, the argument here seems to be that it's really convenient for us to look after it there. But that's not what we're concerned with. We're not looking forward-looking, how are we going to look after this vessel? We're concerned with taking possession of it, and that's all. And it doesn't matter where it's convenient to look after it. Why should it be?
Well, as a matter of construction of clause 29, it should not be very much. No, that is my submission.
Well, the owner may be immediately rechartering it. I mean, it's just not a relevant factor what happens to the vessel after possession is taken. The only question is, where is it convenient to repossess it?
Well, presumably there's no point in just having a ship. The only purpose in owning a ship is to trade it and make money from it. Either sell it or charter it to someone who can trade it, or trade it yourself.
Absolutely. So this particular factual situation is somewhat far from the norm, and perhaps that's had a bit of a distorting effect. But there we are. So I mean, I'm happy to move on from this point unless the court have further. So just a few final As regards the judge's reasoning, you'll have heard what my learned said about what criticisms of the judge are maintained and are not maintained. So I would just like to ask the court to look at, in the owner's skeleton, pages 26 to 27 in the library. Paragraphs 39, where the first sentence is, the judge took as his starting point that the exercise before him was to construe clause 29 against the context of the facts of the present case, and a similar point is made in 44, subparagraph 1. The judge purported to construe clause 29 solely in the context of the facts before him. I submit the judge is not guilty as charged. What he did say, and that is at page 93, paragraph 19, he said that since this matter hasn't come up before in any cases, it's important to confine his construction exercise to what strictly arises on the facts. And the same point appears in paragraph 26 to 27. So the judge was, I submit, quite properly not saying that he was construing clause 29 based on the facts, but that he was limiting the effect of his holdings to what it was necessary for him to say about the effect of clause 29, given the facts of this case. So, for example, he was saying the effect of clause 29 when a vessel is already in a port which the tribunal has held was a port where it was reasonably practicable to repossess the vessel. The effect is this, and he did not need to go on and make further holdings to say, if the vessel had been on the high seas, it would be like this, and so on. So that's what the judge was saying when he is limiting himself to the facts of this case, and that's why the criticism of my learned friend's written argument is misplaced. And then in the skeleton argument, paragraph 44.2, sorry, this is a very brief point, but he said that the judge rewrote the clause to conform to his personal ideas of fairness. But in reality, I submit, what the judge did was to just take into account uncommercial consequences which arose on the owner's construction, and that was entirely in accordance with the law on construction contracts, as the judge had rightly summarised it. And then in paragraph 51 of the owner's skeleton argument, it said that the commentary referred to by the judge, which he didn't find, the judge said he had found a very limited guidance, is David's book. This is also incorrect. If the court looks again at paragraph 19 in the judgment, which is page 93, it's clear here that what the judge was referring to was the commentary in the BINCO notes, which, as the judge says, weren't shown to him. But the judge did not express any scepticism about Mr. Davis's book. He didn't say he found Mr. Davis's book of little guidance or unhelpful or anything like that. I'm pleased to hear that I'm very close to finishing.
Can I say just to ground ourselves here, though, and this is a Section 69 appeal on a point of law, and the point of law is not attached to the facts specifically, though it arises in that context, and we have to decide that point of law as well. So I'm not sure that any of this really matters to anything.
Well, it matters to me, my lord, and that is simply because all of those points were relied on as arguments for saying that His Honour Judge Pelling Casey's reasoning was unsatisfactory. And my arguments are simply attempting to point out to your lordships that His Honour Judge Pelling's reasoning was not guilty of the criticisms that have been made of it. And in those respects, therefore, was not unsatisfactory at all.
I understand that. At the end of the day, we have to form our own views as to what the right answer is, don't we? On a point,
No
of,
dissent
on a point of law.
No dissent whatsoever from me. So there's an important point, though, that has come up about the evidence, and I apologise for getting rather shirty about that this morning. The reason why I felt so shirty then was that my learned friend said to the tribunal something which I considered was clearly incorrect, which is that he asserted to the learned court, forgive me, he asserted to the court that the tribunal had said that repossession would have happened more quickly if the charterers had got on with sailing the vessel to Tregear when requested than it could have happened if the owners had tried to repossess the vessel at Stockton. That was the assertion made. And it's important that I point out to the court that that is not supported by anything in the tribunal's findings. The tribunal did not say that, and there is some background here as to what the limits were on the evidence before the tribunal. So, in relation to the meaning and effect of clause 29, there wasn't really any reliance before the tribunal by either party on these considerations about financial difficulties and so on. What was in evidence was that there had been this termination event consisting of the approval of a pre-bankruptcy and restructuring. So it was in evidence that there had been financial difficulties faced by Tregear. The owners didn't really try to prove, though, that they were subject to any specific level of financial difficulty or inability to raise funds in the period immediately following the termination notice.
I thought there was evidence that payments out of their bank account were frozen and so on.
Yes, although that was prior to the termination notice, but it was in evidence, and it was relied on as part of the circumstances that justified the termination.
There was a dispute whether you could still terminate,
Yes, yes.
whether you'd done it quickly enough and so on.
And one of the things relevant, at least allegedly relevant in that dispute, was to what extent were Tregear still subject to some sort of financial difficulty. So I'm certainly not suggesting there was no discussion of it, but it was in the context of the justification of termination that financial difficulties were in issue.
Possibly if the vessel was redelivered in Croatia, they'd have to pay employees to go on to the vessel and to deal with their yard. I mean, plainly, financial difficulties arise wherever the vessel is going to be repossessed.
I would accept that, and I'm not attempting to steer us now into a discussion of evidence or facts or anything like that. I simply want to make clear that in the arbitration, the stance taken by the owners was not that they were entitled to call for the vessel to be taken to Tregear because they were in financial difficulties or because they didn't know much about shipowning. It was an assertion that they were simply entitled, under clause 29, to choose whatever place they wanted. That's where the owners took their stand in the arbitration. Up until the eve of the hearing, they said they could choose wherever they wanted and they didn't have to pay us. They didn't have to reimburse the costs of getting there. So it was a somewhat extraordinary submission. On the eve of the hearing in the skeleton argument, the position was changed towards accepting this correlative right obligation, and therefore accepting they did have to pay, at least in principle, for costs of caring for the vessel pending a voyage. Although the owners had an argument for saying that on the facts of this case, because of the refusal to go there, they didn't in fact have to pay anything beyond the 21st of May.
That's because you didn't go to Tregear, you went to Gibraltar. And the reason you went to Gibraltar was to get the ship arrested. That was their case. And the tribunal rejected that because Gibraltar's on the way to Tregear.
Yes, the Lordship has seen how the issues played out. But it was accepted in the skeleton argument, in principle, subject to those points. There was this obligation under the correlative right principle for them to pay for the costs of caring for the vessel. But again, it was still argued that there was this, essentially an unfettered right to choose any place, because that's what it was said that convenient meant. Convenient to owners just means we get to choose it. So in that context then, there was not any informed discussion before the tribunal to the effect that if we had decided to try and repossess in Stockton, we would have faced the following difficulty. We lack this, that and the other, or it would be very difficult to engage a ship management company, engage a representative, and so on. None of that happened. There was no positive evidential case that it would have been difficult or time-consuming or impossible or burdensome or whatever for the owners to have repossessed at Stockton if they had decided to try. And the tribunal's finding on the evidence is very limited. And we have visited this already. It's paragraph 137 of the award.
It starts before that, where they find that it was reasonably practical to repossess in Stockton. Previous page,
Sorry, 135. Indeed, my lord, that is the point, that the finding as to Stockton itself as a place where repossession was reasonably practical. But I'm concerned to point out in 137 the limits of what they say they are not satisfied. So we're not satisfied that it would have been reasonably practical for them to have taken repossession on the 14th of May or shortly thereafter.
That's a date, not a place.
I accept that, my lady, but I do submit it's implicit in that what they're saying is at Stockton as requested by a charter, since that was where the vessel was on the 14th of May.
But they also say, well, they say in 135, neither side put forward evidence as to how long it would reasonably have taken. So it's simply a vacuum of evidence on that. But in 136, they do say owners would have had to appoint a ship management company to mobilise the crew. This could reasonably have taken a substantial period. You say there wasn't any evidence of that. Correct.
There's no evidence of what the period would have been. Obviously, it would have taken an amount of time, but there was no evidence as to how long it would have taken.
But it wouldn't have been on the 14th of May or shortly thereafter.
Well, and again, much would depend, my lord, on what assumptions are being made about when they started to try. On page 100 of the bundle, we have our very short chronology, and basically it was on the 13th of April that the charterers started writing to the owners, complaining that there had been this termination event and the owners had kept quiet about it, and warning the owners to get ready for a termination notice. So on the facts, it was not, as it were, a bolt from the blue termination on the 14th of May. There was prior correspondence saying, we're thoroughly unhappy and you should get ready for a termination. Now, none of that, I think, is relevant to the construction clause 29 per se, because there's just the facts of this case. But as it happens, in this case, there was a sort of runway period of about a month when the owners were being warned of an impending termination. Now, if one were to then ask, when does one start measuring the time for being reasonably practicable, I would certainly submit, if it were relevant to decide that one should take into account that runway period of the warning having been given, the charters were going to terminate shortly.
Well, that prompts another question. Suppose that we dismiss the appeal, you win. What happens next? Because the tribunal hasn't, on your case, made findings as to when it would have been reasonably practical. So it has to go back, remit it for. What did the judge do? Did he remit it?
So the judge did make an order remitting the award to the tribunal for reconsideration in light of his holding as to the
Yes.
correct meaning of clause 29, and I am asking the Court of Appeal to uphold his order. So it would result in remission to the tribunal.
Then you could have as much evidence and argument as you wanted as to how long it would reasonably have taken.
But I hope not, my lord, because under the gratuitous bailment and correlative right principle, which is not in dispute between the parties, what the tribunal has held is that the owners are obliged to reimburse the charterers for the charterers' costs incurred in caring for the vessel as gratuitous bailees. And if the charterers were entitled to expect the owners to repossess the vessel at Stockton, then the time that the charterers spent taking care of the vessel at Stockton and then
Mexico.
which is not very far from
Yes.
Stockton, it's just a little down the coast.
But
That
cheaper,
time was-
presumably.
I'm sorry, what?
A bit cheaper, presumably. Mexico.
Indeed.
That was why you moved it down there.
Certain cost efficiencies, yes. So that time is not something of which then the owners can complain as being wrongful, as they can now premised on the tribunal's construction, clause 29. And therefore, the right answer, if I am right on construction of clause 29, is that bailment obligation applies from the time of termination on the 14th of May onwards until the owners take repossession at Gibraltar.
But is it fair to say none of this is a matter for us? All we have to do is decide what the clause means as a matter of construction.
In effect, my lord, yes. But, yes, my learned friend has referred to there being potential for some debate about whether the costs under arrest at Gibraltar are to be regarded as a consequence of one thing or a consequence of another thing. I am not attempting to have the Court of Appeal decide that issue. The judge didn't decide that issue. The judge decided the point of law.
The judge does seem to have said something about it being reasonably practicable to repossess and stop.
Yes, so this is really the final point I wanted to make, other than one brief factual clarification. Sorry, two brief factual clarifications. But yes, the judge didn't, in my submission, take it on himself to make actual findings. What the judge was expressing was a conclusion based on the tribunal's finding that it was reasonably practicable to repossess the vessel at Stockton.
Yes, but it goes beyond that. Paragraphs 28 and 29. It was reasonably practical for the defendant to undertake a task in Stockton and more quick than requiring it to be sailed to Tregear. 28 in far less time. Mr. Oconee said, well, that wasn't a matter for the judge. The tribunal didn't make that finding, and it wasn't for him to make that finding either. Is he right about that?
Well, my lord, this judgment is, of course, very compressed, and what the Court of Appeal cannot now see is necessarily all the submissions which underlay it, and that would include, in my submission, the absence of any case at any stage of the arbitration or the Section 69 appeal, the absence of any case that it would take the owners longer if they were trying to do it at Stockton than it took for the vessel to sail from Mexico.
I understand that, and the judge says it was for the defendant to prove that, but this is an appeal under section 69. The point before the judge was the question of construction. It wasn't open to him to make new findings of fact, and as you showed us from the award, I don't think the tribunal made any finding beyond a very limited one. 135 to 138. So it was reasonably practical to take possession of Stockton, but it couldn't have been done on the 14th of May or shortly thereafter. And it might have taken a reasonable length of time.
Yes.
And that's not what the judge says. The judge goes beyond that and saying it could have been done much more quickly.
The judge may have expressed himself in a slightly unfortunate way, which does appear to go somewhat beyond the task of answering the point of law. I accept. But it's nonetheless, that is not a reason not to uphold the judge's decision on the point of law and remit it. And I think the point that I've always been concerned to underline is the absence of a finding from the tribunal.
Yes.
That if they'd been trying for Stockton, they would still have failed so badly that it would be more than 45 days. I see that the court had that. The only thing I wanted to answer then was, my Lord Justice Nugee, you asked us earlier, what happens in practice if a charterer simply, having given a redelivery notice and being required to redeliver, and then the owner is notified of that, and the owner simply doesn't come to pick up their ship at the redelivery port. That is, it's not a situation that, as far as I'm aware, I've ever come across in practice. Because ships are such valuable assets, obviously owners generally want them back unless they have completely collapsed. But even then, there would be trustees or liquidators who would want them back. But the specific question of can a charterer then simply walk away from the vessel, leaving it there, having consulted with those behind me? The submission we would make is no, it would be highly unprofessional, but also it would be legally very risky, because the master, for example, might be exposed to criminal sanctions if he simply abandoned a vessel at a port. It could be a safety risk.
Well, the port doesn't want a ship clutching up its keys or its anchorages if there's nobody responsible for it.
Absolutely, my lord. But there are port state laws which would likely expose the crew to serious consequences, and potentially also the charterers who employ the crew vicariously.
So it's not really a practical question.
So if this were to happen with a Songa ship, the answer is Songa would remain in possession and control of the ship, making sure nothing bad happened, and reserving their rights to claim damages.
So there isn't really an equivalent of a tenant just posting the keys through the landlord's letterbox, saying it's yours now.
Yes.
It just doesn't happen in practice.
Unless I can access the court.
Anything in reply?
My lords, I will do my best to be as quick as possible. See if I can avoid taking the holiday. Avoid us taking the holiday. I have, if I can read my writing, about 6 points that I have to take relatively short. The final point that my learned friend made there, I hope I don't have to deal with, but there's a suggestion that I have somehow misstated what the tribunal found in 135 to 137. I hope that it was clear what I was saying, to your lordships too. I don't suggest that they made a positive finding on the matter. Now, the real first point I want to make in earnest is this. The lordships asked my learned friends to what is construction of a port or place convenient to them means in the context of Clause 29. And as I understand it, his answer is that it's there to ensure that the vessel is repossessed at a port or a place where an authorized person and crew can be put on board. And so he gave you the example of perhaps the vessel being in northern Russia somewhere where it would be impossible to get people on board. And then he also adopted my Lord Justice Nugee's point about the waterfall. So the way it works is the current port, and failing that, next port, then failing that, a port or place of convenience to owners. My lords, I have my lords and my lady, I beg your pardon. I have 2 points in respect to that. First, if what was intended really was just to ensure that the authorised person is able to be transported to and board the vessel, all that would be required in the clause is to say the vessel is to be at a safe port or safe and or ice-free port. That is all that would be required. It's the usual conventional way of ensuring that the place the vessel is calling out is safe. We saw that in clause 15. Charters are required to put it in a safe and ice-free port. So in my submission, it can't be that what the clause is driving at here is really about the ability of the authorised person to board the vessel. It's got to be more than that. The second point is this. The construction that my learned friend is suggesting to you, and in fact the construction that the judge adopted, necessarily involves what is a bit of a confusion, I might say a sleight of hand. Because if the purpose of a convenient place of port is to deal with a situation where the authorised person can get onto the vessel, then how is it that my learned friend accepts, and the judge suggested, that if the vessel was supposed to sail to the next port, so termination happens while the vessel is at sea. If it's in New York, close to New York, and the discharge port is in, or the next port is in Japan, my learned friend's submission is that somehow owners are required to nominate a different port. Well, what is the basis upon which owners are supposed to do that? What right do owners have to nominate that port? Because a place or port convenient to them is already doing work. It's already being said to mean only that it's a place that owners can send an authorised person. So it can't follow that those same words are the words that allow the owners to nominate a different port from the next port. And so if one adopts the approach that my learned friend suggests and the judge adopted, one has to grapple with that point. And I say, that is because it does not make sense in the wording of clause 29, it points in the direction that is the wrong construction of clause 29. Now, my learned friend also took you to the BIMCO documentation as well as...
Sorry, is this point 3, are we still, or is this part of point 2?
Pardon, my lady. This is point 3, but the real point 2. I think point 1 was just to clarify that I hope...
That was the warm-up, was it?
I hope I didn't mislead.
Not at all.
And so, let's call it point 3. My learned friend took you to the BIMCO documentation and to Bevo Charters, Mark Davis, and pointed to what he said the mischief that clause 29 was trying to deal with. And that mischief was that there was a risk that charterers would leave the vessel at a place that is difficult for repossession. And then you were also shown the part that the vessel might be left at a distant port or the seas. I accept that that is certainly a mischief that is trying to be dealt with by clause 29. I also accept that a way that the clause seeks to deal with that mischief is by designating the charterers as gratuitous bailey. But it is not obvious why that is the only way that the mischief could be dealt with. Giving owners the option to select one of 3 places to have the vessel redelivered also deals with that mischief. So there really is nothing to the point that, oh well, this is the mischief that's trying to be dealt with. Well, yeah, that is fine, but my construction also deals with that mischief.
In what way is this an election between 3 places? Because if you have the right to elect a convenient place or port, then what does it add to have current or next?
And so this was point 5. This is the point that the current or next become OTOs if I have two answers to that. The first is this: it does not follow that if I elect the current port or I elect the next port, that those ports are necessarily convenient for me for the possession. It may be that the relationship between owners and charterers have completely broken down and I don't want charterers sailing my vessel anywhere. It may be that the vessel is under arrest at the particular port and so it would be difficult to get it to sail anywhere else, or the vessel is in disrepair and so it would be difficult for me to get it to sail anywhere. And so while we're in a port that would be inconvenient to me to get to, I elect that port nonetheless. So that's point 1. In my submission, it does not follow on my construction that current port and next port or O2s were necessary. Second point is a so what submission, my lord. Even if it is correct that convenient port somehow subsumes current port and next port, in my submission, the authorities are clear that the presumption against surplusage is not a presumption it's not a rule that's supposed to take significance in interpreting commercial contracts. And in my submission, that's the case even more so in the context of standard form contracts. You always have some tautology, some overlap in an attempt to be overly cautious. So in my submission, that should not be a pointer against, given the provisions, the first sentence, the ordinary meaning. And my lord, if I need to give authority for the point that the presumption against surplusage does not go very far in the context of commercial contracts, the answer is in actually His Honour Judge Pelling case's own judgment in a different case called Palmat. And just in case you just want to have a look, it's not a very long point, it's a tab 6, and it starts at page 83, paragraph 20. His Lordship starts to articulate principles governing construction. And if you look on page 84, Roman 8, language used by the parties should not generally be treated as surplus, but it is well established law that the presumption against surplus is of little value in interpretation of commercial contracts. One of the things that is interesting in this judgment is that although His Honour Judge Pelling essentially cites almost verbatim the same principles in the current judgment, he seems to have missed out the one in Roman 8. But that is a point that I say is just standard principles of construction contracts, commercial contracts. So I think my point 5 became my point 3. Wait,
4, I think.
became my point 4. My new point 5 is a short point that relates to the reliance placed on the interpretation of Clause 29 by Mark Davies in his book, Rabbit Charters. The point is a simple one. While it is legitimate for your lordships to look to the book and the commentary for the purpose of the clause, his view on what the clause says is no more authoritative than a 3-member LMA panel of very respected shipping lawyers. So it really takes us nowhere as what he thinks Clause 29 means. It's certainly useful for the purpose of understanding what 29 was there to do, what the mischief it was there to deal with. But I say that his view on the meaning does not go too far. And on that point, this is a small point, and I understand that I don't want to take too much time on it. But my learned friend pointed to, perhaps it's worth going to it very briefly. It's tab 8 of the authorities bundle. And the relevant points that I wanted, at 2921, page 113. At 29.2 in the middle paragraph, my learned friend relies on the suggestion that there is some drafting infelicity in respect of the words without hindrance or interference by charterers, courts, or local authorities. It says they're enacted insofar as they relate to courts, but it's submitted that the intention is clear. Not having a relevant default, owners are entitled to withdraw the vessel without the need for any court order. With respect to Mr. Davis, that's clearly not what the clause says. The clause is not dealing with owners not needing to get a court order to repossess the vessel. What the clause is saying is that charterers, as my learned friend said, charterers cannot stop the repossession by going to court and getting an arrest order, for example. And in my submission, that's just clear from the words of the clause, and there is no, this is not an example of the clause being badly drafted. Point 6, my lady. There was a debate that has developed as to what one can consider when it comes to what is reasonably practicable, or when it is reasonably practicable for the vessel to be repossessed. My learned friend says that you cannot take into account any subjective characteristic or features of the owner. In my submission, that cannot be correct, because the effect of that really is to simply have a clause that says you must repossess the vessel as soon as possible. Reasonable practicability necessarily imports different factors. And I don't say that, for example, there's obviously always a limit of how much subjectivity one can have. But one factor that I say clearly can be taken into account is the fact that the owners are insolvent or in insolvency proceedings. And the reason I say so is that the very premise of clause 29 is that there's been a termination pursuant to clause 28. And so one of the basis or one of the scenarios you can terminate for purpose of clause 28 is owners' insolvency and owners being in insolvency proceedings. It cannot make any sense that the parties would understand that owners may have difficulties arising out of their financial position, which gave rise to clause 29 being triggered, but that is not something that one would take into account when assessing whether or not, or when it is reasonably practicable for them to repossess a vessel. Now, it does not follow that because owners are in difficulty financially, it will always take a long time for them to be able to repossess the vessel. But again, the point about reasonable practicability is that it will always depend on the facts of the case. And so it may be that although I'm an insolvent party, I've got liquidators in place, it's completely simple for me to be able to get people to pay them because, for example, they will rank higher than everybody else because it's a cost of the liquidation, and so it's not a problem. But that lies at the heart of the point about clause 28 and 29. 29 is trying to deal with a large range of different situations. And so one can't just pinpoint one example and say, well, this is how it works in this situation, so it must account for everything. What 29 does, in my submission, is it gives that flexibility for the parties and especially the owners to be able to respond to situations by giving them the right to decide where the vessel is supposed to be repossessed, subject to the guardrails that I described earlier. There's a point my Lord Justice Phillips made earlier, and it's probably not a big point, but I will just deal with it briefly. I think the suggestion was that the discussion about Trogier being a reasonably practical place for repossession of the vessel was actually a discussion about where it would be reasonably practical for owners to take care of the vessel rather than to repossess the vessel. Again, as I said, I don't know that it goes very far because it's not a dispute on fact, it's a dispute as to the construction of Clause 29. But what the tribunal was saying is that it was looking at repossession. In order to repossess the vessel, you would need an authorized person on board. From the tribunal's perspective, there was a chance that it would take a substantial amount of time for owners to get a reasonable person on board. And so what they were saying was that Trogier was a place that was convenient for the purposes of repossession, bearing that point in mind. So it's not really about whether the vessel can be taken reasonable care of, it's where it can be repossessed. Two final points. This is probably a non-point, as I understand it, your lordships are clear on it. But my learned friend points at various paragraphs in my skeleton argument where he says, well, I criticised the judge wrongly. Now, I did not take your lordships and your ladyship to that point because it was made clear at the beginning that the focus is on construing the clause. But I certainly maintain all of the criticisms that I make in my skeleton argument, but I'm not going to take your lordships and lace it through all of that at the moment. Now, the final point, and I'll sit down, is this. In my submission, my learned friend, in the early part of his submission, essentially gave the game away. Because on his submission, he says, I think something to the effect of, perhaps if we were drafting this again, this might have had another 10 to 20 lines in it. But the parties have tried to pack everything in, or the bingo dress people have tried to pack everything in. And it's not a very well drafted clause. Well, it is correct that if you wanted the clause to say something completely different, it's not a well drafted clause to that effect. And you would, in fact, need 10 to 20 terms, lines to be able to get the construction that my learned friend is advancing. But if one looks at what the clause actually says, and for a moment give the drafters of the clause the benefit of the doubt that they meant what they said, then it is clear that the ordinary meaning of those words is to give owners the option to pick or where to repossess the vessel. It is only because of an instinctive pushback against the idea of the consequences of that one ends up saying, oh, well, this is a badly drafted term, and in fact, you need 10 to 20 more lines in it. In my submission, that is not an appropriate way to go about the exercise of construction. What does the clause say? Is it unclear? If it's unclear, then we can get into discussions of trying to make it make sense. But it's not unclear. And in my submission, it simply means what it says. Unless I can give any further assistance, it's my submission.
I think my only question for the parties is, are you obtaining a transcript of today's hearing?
I haven't got the handouts on here.
My lady, I'm sorry, it can be done, but I don't think the issue has been considered at all. We can certainly ask for one, if that would be helpful.
If you can ask for one, it would be helpful.
You'll have to sort out the costs between yourselves. I'm afraid. No transcripts at public expense. Thank you very much indeed. Well, thank you. Oh, yes.
I'm so sorry, just to say, do I understand correctly that it would be welcome if we find between ourselves, sort out the obtaining of the previous BIMCO Bearcon standard form to the court's
Yes.
clerk?
If you, my clerk, please. And I don't think need worry. I don't think, as we suspect, once we've had an opportunity of looking at it, it'll simply show complete absence of a clause 29 equivalent. So in those circumstances, I don't think we're going to need any written submissions to tell us, read it and you'll see it's not there. We can work that out.
So for now, we'll simply attempt to find this.
You happy with that? Or do you want
That's
submissions?
fine, yes. I think it's readily available. But you
But
may,
they probably have it.
you probably will have
They
it.
probably have it. I'm sure. Or at least your instructing solicitors will have it, I'm sure.
There may be an edition, the previous edition of the history may have it as a.
Yes, we don't mind where it comes from. It's just really belt and braces. Thank you both very much. Well, I don't think any of you will be surprised at all to hear that we're going to reserve our judgments. I'm not able to tell you as yet when we'll be able to produce those, but we're conscious this matter has been going on some time, and so we'll endeavour to get them as speedily as we can. You'll be sent them through in the normal way, in draft, just for typographical and minor imprecities, please, not as an opportunity to re-argue the case, tempting though that may be. May I just remind you about the terms of the embargo on the top of the draft judgment and ensure that only a very limited people have an opportunity to see our draft, because of course it is a draft until such stage as we've taken into consideration any amendments from you and hand it down. We're conscious that this is a clause that is widely used by people within the industry, and so it would be most unfortunate if a draft found its way into the public domain. So, hopefully we can deal with all other matters on paper. Any further disagreements between you, we'll hear written submissions, and I'd hope ultimately you'll be able to agree an order for costs. So thank you very much, both of you, and for the people that have assisted you in the preparation of the case. Thank you all very much.
All rise in favour.